2 different cases, 2 different systems, and 2 types of ambiguous circumstances, and yet they followed the exact same path to conviction, because in both, the most persuasive exhibit wasn't what was found, but what wasn't. The empty space where evidence should have been. A gap appears, and uncertainty enters the system. And instead of protecting that uncertainty, the system replaced it with a story, a pattern, and a suspect. And in Kathleen Folbigg's case, science didn't yet exist to explain what happened. In Lucy Letby's case, a hospital couldn't confront what was happening inside its own walls. Different failures, same trajectory. Today we go inside both cases to watch that process unfold in real time, because what begins as a gap in science, in oversight and accountability ended in 2 criminal convictions. And in 2026, one of those cases is still unravelling in ways that the original verdict never anticipated. First, the Kathleen Folbigg case in Australia. Investigators believed there had to be an explanation for the deaths of the 4 Folbigg infants beyond sudden infant death syndrome. So an idea formed gradually as scientific uncertainty met institutional pressure and a justice system unwilling to sit with the possibility of not knowing. And once that idea took hold, the evidence didn't need to exist anymore. At the time, medicine didn't understand genetic heart arrhythmias or that they could cause sudden infant death. The CARM2 mutation had not been discovered yet. Infant genetic disorders were barely understood. No one could explain these deaths. And this is where everything changes, because into that silence came something dangerously simple. 1 sudden infant death is a tragedy, 2 is suspicious, and 3 is murder, until proved otherwise. This is Meadows' law. It sounds like science, but it isn't, and once it entered the courtroom, it filled the space where evidence never existed. Meadows' law is nothing more than a phrase Sir Roy Meadows devised to frame repeated infant deaths in a family, not as a medical unknown, but as a presumption of suspicion. But that phrase became a lens for the evidence that did not exist. And once that lens was in place, the investigation changed course. The question stopped being what happened to those children and became how do we prove the mother did it? But here's what no one in the investigation was asking. If the science didn't yet exist to explain these deaths, what was the prosecution building its case on? Kathleen Folbigg's diaries slid into this void, the empty space where reliable evidence never actually existed. Kathleen's expressions of grief, guilt, and maternal self-blame were interpreted as confessions. Everything changed from that point on, despite no identifiable mechanism of harm to the infant. There was no medical explanations, no forensic cause of death, but the narrative had already formed, and what filled that gap would go on to convict her. And this is where the deeper institutional failure emerges. Rather than acknowledging the limits of medical knowledge in the absence of any direct evidence, the system defaulted to the most socially understandable explanation. The mother must be responsible. Speculation didn't stay speculation. It hardened into evidence. But here's the problem. That isn't just a flaw, it's a mechanism. And this is the moment the case turns, when science finally caught up. By then, the damage was already done. And this is a moment in a case that truth tends to reveal itself. Then, during the 2022-2023 inquiry, international geneticists identified the CARM2 variant. It was a credible biological explanation for 2 of the deaths. Not hidden, not suppressed, simply beyond what forensic science could see in 1999. And that is where the question becomes unavoidable. Not was Kathleen Folbigg guilty, but why does a system facing scientific uncertainty so consistently reach for a human culprit? Is it because uncertainty becomes unbearable when a child dies? Or because complex biological reality offers no emotional closure? Admitting we do not know is institutionally harder to say than constructing a narrative of guilt. Whatever the reason, the Folbigg case exposes something structurally dangerous. When evidence is incomplete, the justice system does not always remain neutral. Sometimes it compensates for the absence of evidence. It manufactures certainty where the evidence only offered doubt. And this is where Meadows' statistical assertion should have disappeared, because in law the Blackstone ratio is a legal safeguard. It's better that 10 guilty persons escape than the one innocent person suffer. Because once a system fears uncertainty more than a wrongful conviction, tunnel vision stops being a mistake. It becomes structural. And if this was a single case in a single decade, in a single country, you could call it an outlier. But it isn't. Because while Kathleen Folbigg waited in prison, the same process was beginning again in a completely different country, in a completely different institution, to a completely different kind of person inside the system. But this time, science wasn't the problem. This time, the system can't hide behind it. The neonatal unit at the Counties of Chester Hospital, where Lucy Letby worked, was under strain, understaffed, overstretched, unsafe, and when this happens, failing systems crave simple explanations. Concerns were raised repeatedly and ignored repeatedly. The third wall inquiry later confirmed that consultants consistently raised concerns about safety on the unit, only to be ignored, sidelined, or pressured to apologise. But when babies began collapsing and unexpectedly dying, these failures weren't treated as explanations. Something else was. And once that shift happened, the outcome was already narrowing. And the same pattern in the Folbigg case re-emerged. But there was no mechanism, no forensic evidence, no unified medical explanation. A pattern is simply not proof, but it became enough to convict. And just like in the Folbigg case, the question changed from what was happening in the hospital to how do we prove she did it. The investigation narrowed long before investigators had identified a single piece of evidence. And that matters. Safeguards existed at the hospital, they just weren't used. Safeguards only work if institutions are willing to apply them. And so we have two cases, different decades, different institutions, different categories of death. And yet, in the Folbigg case, science could not explain the deaths of the 4 children. The cause was genuinely unknown, so the investigators reached past the blank space where evidence should have been and found a mother to convict. In the Letby case, a failing neonatal unit could not explain a cluster of infant deaths on a single ward. The institutional cause was genuinely uncomfortable to confront, so the investigators reached past the system and found a nurse to convict. In both cases, the discomfort was real, the grief was real, and in both cases, the need for an answer was real. But in both cases, the conclusions were reached before a single piece of evidence had ever been identified. This is not a coincidence. It's not an isolated failure in 2 distinct isolated systems. It's one pattern repeating under different conditions, and it's accelerating. And understanding that pattern is not just about Kathleen Folbigg, it's not just about Lucy Letby. It's about what happens inside any institution, whether it's legal, medical or governmental, where the pressure to find an answer becomes greater than the discipline to find the right conclusion. And one of those cases is not over. Not the appeals, not the expert testimony, not the science. In 2026, every pillar that the Letby conviction rests on is being re-examined, and that same institution that built the case is now being asked to dismantle it. Now, I'd like to return to 15 May 2017, a meeting that changes everything. What happens next is crucial. 3 consultants arrive clutching documents. On one is a cluster of infant collapses, on the same ward, on the same shift, all logged aside the same nurse. What they brought into the room was a pattern, and that's all it took. From that moment forward, the investigation wasn't open anymore. What they didn't bring into the room was a mechanism of harm. There was no forensic evidence, no medically validated cause of death, no explanation for why the collapses occurred, only when they occurred and who was present. And critically, no full account of the unit's own systemic failures in the months prior. And these absences didn't slow the investigation, they shaped it. The police were meeting with Dr. Stephen Berreley, Dr. Ravi Jaraman and Dr. Susie Holt. And from that moment on, the investigation turned into an institutionalised tunnel vision. The question subtly shifted from what was happening inside this failing neonatal unit to how do we prove the nurse was responsible? The police could have initiated a full systems review, one capable of examining staffing levels, clinical procedures, equipment issues, escalating failures and organisational dysfunction. Instead, the investigation centred on a single suspect. The unsafe conditions surrounding the unit became peripheral. The individual nurse became central to their investigation. When systems fail to interrogate themselves, complexity becomes evidence of the problem they don't want to see. And just as in the Folbigg case, uncertainty itself began to function as incriminating evidence. There was no consistent forensic mechanism tying all the deaths together, no universally accepted medical explanation proving deliberate harm across the cases, and yet the narrative continued to solidify. The pattern became the proof. Once suspicion acquires momentum like this, ambiguity starts looking like guilt. And this is where the Crown Prosecution Service should have functioned as a safeguard. The CPS's job is to decide whether the case can realistically secure a conviction. And this is where the system should have stopped it, but it didn't. In Folbigg's case, the system filled a gap in the science. And in Letby's, it filled a gap in accountability, and in both, the answer came before the evidence. Then there's the expert testimony. The prosecution's lead expert, Dr. Evans, had done this before. In 1988, he alleged that understaffing had contributed to deaths at a Swansea neonatal unit. These claims were later rejected by an official inquiry. And this is where the system reveals itself, because a 2026 review suggested that experience shaped his approach in the Letby case, focusing on individual culpability rather than the system that employed her. When experts fear institutional backlash, systems stop being scrutinised. And that may be the most important parallel between Folbigg's case and Letby's. Uncertainty was not treated as a reason for caution. It became the moment doubt was reinterpreted as guilt. In Folbigg's case, the system could not explain the death scientifically. In Letby's case, the system struggled to confront institutional collapse. But in both investigations, the absence of clear answers narrowed down to a single woman. And now, years later, the lens widened. In 2026, the CPS confirmed that no further charges were being brought against Lucy Letby, despite police requests for additional prosecutions. At the same time, corporate manslaughter investigations into the counties of Chester Hospital and senior management remain ongoing. The focus is no longer exclusively on one nurse. There is now growing scrutiny of the system itself. It's only when the lens widens does the system come into view. And that leads to a deeper legal question running beneath both cases. Why do institutions so often find it easier to blame a single woman than to confront the limits of science, medicine, or their own organisational failures? Perhaps because a lone suspect offers emotional closure, or perhaps because institutional failure is too diffuse, complicated and politically dangerous, because omitting uncertainty threatens public confidence in the system itself. But these cases expose the danger of allowing meaning to overtake evidence, because once an institution becomes afraid of uncertainty, then wrongful convictions, tunnel vision stops being an investigative error, it becomes structural. What makes these cases so unsettling is how easily the pattern forms. A gap in the evidence opens and a simple story moves in to fill it. This isn't just about Kathleen Folbigg or Lucy Letby. It's how quickly the same structure appears again in different countries, different systems, and different evidence. Yet the trajectory is almost identical. A gap appears, uncertainty enters, and instead of protecting that uncertainty, the system replaces it with a story, with a pattern, and with a suspect. Because uncertainty offers no closure, no resolution, and no one to blame. But manufactured certainty, even false certainty, restores the illusion of control. And that's when danger begins, because when a system fears knowing that is wrong, it stops safeguarding the truth and starts manufacturing blame. And that's why the Blackstone principle exists, not as a theory, but as a warning. When absence becomes evidence and doubt becomes suspicion, then the only real question is, how many times has it happened already? If this matters to you, share this video, like and subscribe. I'll see you in the next one.